Okay, good afternoon. Welcome, everyone. My name is Ashley Paleka. I'm Vice President of the Hispanic Law Student Association. Thank you for being with us today as we explore questions of peace and transitional justice in Colombia. On behalf of the Hispanic Law Student Association and the Center for Civil and Human Rights, we would like to thank Professor Cassel, in addition to the Kellogg Institute for International Studies, the Prof Institute for International Peace Studies, and Notre Dame Law School for lending their support and making today's timely discussion possible. Without any further ado, we would now like to welcome Andres Lopez, who is a native of Colombia and also an international human rights candidate, who will set the stage for Professor Cassel's discussion today.
Well, thank you so much for the invitation to participate in this event, especially to the CCHR and the Hispanic Student Law Association. So the structure of what we're going to do here is I'm going to make a very brief remarks to set up that conversation, summary of the peace process and the armed conflict in Colombia of 5 minutes. Then Professor Cassel will address you us in his remarks, and at the end we're going to have a conversation, or I'm going to ask him questions and he will answer them. So the first thing I have to say is that thank you for your interest in this. This is absolutely important and relevant for me. This is the most important event for my generation as Colombian. I don't know a Colombia without war. I haven't lived that yet. So this is quite important for me and for all the Colombians that are sitting here of the same generation. So this is quite relevant. And so the first thing I have to say of this conflict is that the FARC and the government are not the only actors of the conflict, the armed conflict. It has been 52 years of war between the major leftist group, the FARC, and other minor guerrillas, the ELN or the EPL, other two guerrilla groups, and the paramilitaries, which are the right-wing groups, and the government. So it's been a conflict that part of the paramilitaries were demobilized years ago, only part, other percentage, maybe 30% of the paramilitaries were involved in a different kind of criminal organization. So after 52 or 3 years of armed conflict, in 2010, the President Santos and the FARC began conversations in secret, preliminary conversations, in trying to reach a first agreement, like building a framework for the process of conversation. In October 2012, the Colombian government published a document that negotiated with the FARC, in which the parties settled the principles of the negotiation process. One of the principles that is very important of that agreement is that in this process, everything is interdependent. So if something of the agreement in the peace process goes down, all the agreements goes down. It's everything or nothing. So that's an important thing to have in mind, especially with the results of the plebiscite. So the public talks held in Havana, Cuba, lasted for 4 years, between November of 2012 and August of 2016. The result of this effort was an agreement of 300 pages, almost 297 pages, that contained 6 sub-agreements. Those agreements are about land reformation, political participation of the FARC, victims reparation and transitional justice, solutions for the drugs problems, and implementation mechanisms. So it's a huge agreement. Now we're going to discuss mainly transitional justice mechanisms within the agreement. But it's a remarkable achievement with a lot of structural issues in the agreement. During the time of intense negotiations, our professor, Dr. Cassel, participated in the design of the transitional justice mechanism of the agreement with an elite team of other lawyers from Colombia representing the government, but we will talk about that later. And I have to say that this participation made us very all proud. I, as his student and as Colombian and working here in the law school, I'm very proud that Professor was involved in that discussion. And not because, I mean, from all universities and all professors that could have been involved, was Professor Cassel the one involved. So I'm very proud of being his student, and of I think we're lucky that Colombia has somebody like him in that process. So, but this is not the only participation of Notre Dame in this negotiation process and in the peace process. The Kroc Institute was also invited to monitor the implementation of the agreement, which is essential for real peace. And now, although the agreement was officially signed on September 26th in Cartagena, where Professor Doug was in first line, and it was presented before the General Assembly as something done, like a fact. The agreement was really, the people of Colombia had really needed to referend the agreement. So, in October 2nd, the plebiscite, there was a plebiscite where Colombians had to answer to the question if they rejected or accepted the agreement in a binary answer of yes or no. So, as you can see, it was a hard choice. You have only yes or no to evaluate 6 years of negotiation and 300 pages of agreement. And the unexpected result was that the no won, right? 51% roughly won, so the agreement didn't pass. So we don't have agreement in theory. And so how to read this no? Just very briefly, one interpretation of this no is that Colombians want war. So that's why they say no to the agreement, which I think is irrational to think that. No one wants war, right? But I think it's important because that was the campaign of the government in some ways, saying if you vote no to the agreement, you really want war. And that was kind of the idea. So that's not what really happened. So what's the reason behind the no and part of that? There's some relation with transitional justice issues, but I think there are two possible explanations. One is the influence of former President Álvaro Uribe, who is now the head of the opposition. Now, I think that's true, but I think it's partial, because probably he is not that influential to convince all Colombians to say no. I think there is also other reasons, rather than you being a Uribista, like following Uribe, to say no to the agreement. And I'm just going to list them before just I introduce Professor Cassel. So some of the reasons that can be explanation of the no are part of the illegitimacy of the process, because not all political actors and social actors were included in the negotiations, only the FARC and the government. So that might be a reason why. And this illegitimacy is relevant because part of the agreement, or the agreement, is going to become part of the Constitution under the doctrine of constitutional block or bloque constitucionalidad. So that it. The other second reason is the problematic participation of the FARC in politics, especially that there are 10 seats granted for the FARC members in the Congress, and roughly like around $1.2 million that is going to give the state to the political party of the FARC, which is paid by Colombia's taxes. And special access to regional communication and financiation of the political think tanks of the FARC, other similar stuff related to the political participation. A third issue, which I think Professor Cassel will address later, is the idea that there is weak punishment and ineffective reparation to victims because there is no jail for victims. There is other alternative sanctions. I'm not defending these positions, I'm just listing them in a descriptive way, right? The fourth reason might be that the lack of commitments related with money and property illegally obtained by the FARC. The FARC doesn't have an obligation to return those money, or they're going to keep it in theory. However, the FARC, they say they don't have anything, but Forbes say something different. lack of commitments related with the return of children involved in the conflict. 6, lack of commitment related with narco traffic, routes, money, and contracts. There is no real obligation about that. Other minor issues, but I think they are very influential, is that, for example, guerrilla members are going to receive a salary that is higher than, for example, soldiers. So it's like, well, soldiers have been fighting for us, and they're going to be paid all their life less than guerrilla members that they're going to be part of this process. There's 8 reason, there's no judicial supervision of the land expropriation mechanism that is part of the agreement. And I think the last one, the reasons for there to, is several of the reforms necessary to implement the agreement requires to change the constitution of Colombia. And a lot of sectors are saying that's not possible if the people is not involved in that. It should be like a referendum where people say something about the constitution, but not through this like backdoor of modification of the constitution. And lastly, and I think it's not a minor issue in the sense that motivated a lot of votes against the agreement, is the presence of what is called the gender ideology in the agreement, which I'm not going to go deep on that, but it's the idea that part of the Christian evangelical communities and part of the Catholic Church have been promoting the no is because there is this implicit idea in the agreements that the conflict, the roots of the conflict are really stigmatization and discrimination of minorities and women. So including within those minorities, LGBT people. So under this interpretation, part of these communities are saying that this might create a risk for later when the agreement becomes part of the constitution to like push forward this kind of agenda for same-sex marriage or other issues. This is just an idea and a hypothesis. You might agree or not, or whatever. So, saying all this, I hope this just set the table for what Professor Cassel has to say. There's a lot we're afraid of right now. I don't think there's coming war really. War is not showing any options really or intention to go to war. But there are 2 possible outcomes of this. One is that the agreement might get modified after President Santos hear all the political actors that were not involved in the prior negotiations. So the agreement might change, and it has to go to Havana again and have a renegotiation process with the party. That might be one option. So that opens possibility to include, for example, the ELN or to change issues of the agreement. Another option is that the agreement is not going to get modified, the parties are not willing to accept these things, and there's this legal theory that might be the agreements are already binding because they're in a special agreement under Article 3 common to the Geneva Conventions, so they don't need to be kind of implemented. They're already like kind of international agreement which is already binding. So there's these things for the no that they're unresolved and often present. So now let me introduce Professor Cassel. I have talked a lot. Sorry. So Professor Cassel joined the faculty of law school in 2005. And here, BA Cumulative from Yale in 1969 and a J.D. from Harvard Law School in 1972. Professor Cassel has a quite remarkable experience. He's a scholar, a practitioner, and a commentator on international human rights law. He has represented victims of human rights violations from Colombia, Guatemala, Peru, Venezuela, and appeared as an expert witness in cases in the InterAmerican Commissions of InterAmerican Court of Human Rights. This is not the first time Professor Cassel is involved with transitional justice issues. He has experience. He served as a legal advisor to the United Nations Commission on the Truth for El Salvador and to the executive council member of the American Association of International Law and other positions similar. So we're very lucky to have Professor Cassel here. I'm going to just give the floor to him and please welcome him here.
you, Andres, for that very helpful overview of the peace process in Colombia. As you can hear, my voice is not in tip-top shape, and so he has saved me a great deal of time. I've had to use my voice to explain to you. Let's see, this is October of 2016, so I guess it was almost 2 years ago that President Santos asked the United States government to become more involved in the peace process in Colombia. Up until that time, December of 2014, the Obama administration had sort of had a hands-off position on the peace process. Watching it from a distance, obviously they favor peace, but this is the fourth peace process in the last 25 years in Colombia. And the other three have all failed. And there was lots of reasons, and you heard about 8 or 10 of them just now, why this one may fail too, we don't know. So the Obama administration did not want to become heavily involved until there was reason to think that there was good hope, good chances. And when President Santos personally asked them in December to do it, they agreed to do it. And in February of 2015, the president named Bernie Aronson as a UN Special Envoy to the peace process. Bernie had been Assistant Secretary of State for the Western Hemisphere during the peace processes in Central America 25 years ago, including the Salvador peace process. And so it was thought that he had some idea of how to help make peace. And also he has very good relations on Capitol Hill with both parties. Shall I repeat that? Did you hear that? He may be the only person alive that has very good relations with both parties on Capitol Hill. And obviously, congressional support would be needed if the U.S. were to give material and other support to the peace process. So Bernie was an excellent choice. Life is full of coincidences. I'd like to tell all your students out there that all you have to do is work hard, get straight A's, accomplish everything you can within your sphere, and good things will come to you. Maybe. Sometimes it takes luck. Bernie is not a lawyer. He's an accomplished diplomat and a successful business person. But over the years, Bernie has asked me to help him on various pro bono projects. So I've known Bernie for quite a number of years. And he asked me to help him. He said, I need some legal help here. I said, of course, I'd be honored to help. At that same time, the negotiations hit a roadblock. Many of the issues that are on the agenda that you heard mentioned by Andres have been partially resolved, but there was one elephant in the room that they could not get past, and that was the issue of transitional justice for the atrocities. The atrocities that led to 250,000 people dying in this more than 50-year-old civil war. 6 or 7 million Colombians being internally displaced out of a population only 6 or 7 times that large. Massacres, forced disappearances, sexual violations, recruiting of child soldiers, every conceivable violation of international human rights and international humanitarian law had taken place. The government negotiators and the FARC negotiators had been talking about it, and they had reached this point. The government was insisting on prison time for the FARC, understandably. The FARC was saying, absolutely no. We are not going to accept not one day in prison. We are not a defeated military party. Our numbers are down. We're on the defensive. After all, President Uribe had just spent I don't know how many billions of dollars in U.S. military aid and in Colombia to defeat the FARC. They couldn't defeat them, but they did have them on the defensive. Their numbers were down, they controlled less territory. But they were still there in the field. And unless Plan Colombia were to continue at the high level of funding it had, and even if it did, it would be many years before the FARC could be militarily defeated. At least that's what I'm told by the military experts. I don't pretend to be one. And so the FARC said, no. That's a non-starter. You want us to go to prison? we can leave Havana right now, and we'll go back to the mountains and the jungles, and this civil war will go on. So the two sides were completely at an impasse. In May, I did a little bit of consulting with the Colombian government about various plans that would have included prison time for the FARC. Finished my consulting, came back to Notre Dame and thought, well, there's another loser of a project that I've been involved in. Human rights cases are not easy. But in May of 2015, President Santos called and said, we've decided to create basically a second track for the negotiations on the issue of transitional justice. We're going to create a committee of 6 lawyers, 3 for each side, and we're going to lock that committee into a room and say, basically, don't come out until you got a solution that is acceptable to both sides and, crucially, would meet the standards of international law, international human rights and international humanitarian law. And you guys work on that, present it to us, and we'll go from there. I was, of course, honored by the call. I accepted. The 3 government representatives, in addition, well, 2 in addition to myself, were both former presidents of the Colombian Constitutional Court, outstanding lawyers, experts in Colombian constitutional law, of course, but not experts in what I teach here at Notre Dame, which is international human rights law, including accountability for gross violations of human rights. So my role on this 3-member team for the government was to be sort of the watchdog for international human rights and international humanitarian law standards. And then the FARC had 3 lawyers on their side. I think, in all candor, I think President Juan Manuel Santos also wanted to have some assurance that whatever agreement we came up with would be acceptable to Washington. And he knew that Bernie and I are close and thought that probably meant a good running head start on Capitol Hill for an agreement that we would negotiate. We spent 5 or 6 months, many meetings in Havana where the main negotiations were taking place, and in Bogota, which was more convenient for some of us. Long hours. None of you students in the Kroc Institute of Peace Studies should be hearing this, but yes, at times, the meetings were shouting matches. We were not always super diplomats, but there was political will on the part of both of our principals and political will on the part of all 6 of us in the room. And so we got over our occasional temper tantrums and kept trying to work our way through. And by mid-September of 2015, we had a proposed agreement for the 2 sides to sign, which in my opinion at the time was not good enough. But it was kind of a rush job because the Pope was due to arrive in Havana that Sunday, and the FARC very much wanted to be able to announce this in the presence of the Pope. They missed the deadline, so we rushed together this thing. It was announced in Havana by President Santos and by Comandante Timochenko, the head of the FARC, with a handshake. Now this was what you might call an involuntary handshake. Raul Castro, who was the host of all this stuff, stood in the middle, and the 2 guys came together. President Santos came out, and he was like this. It looked like his hands were tied to his legs. There was no way he was going to shake the hands of this girl. And Raul Castro reaches over and grabs his hand, and it just barely managed a handshake. But it was a forced handshake that didn't last because within a week, both sides were sniping at each other over what they had supposedly agreed to. It was obvious that they didn't agree on what they had agreed to. So meanwhile, I was back here at Notre Dame, fulfilling my responsibilities as a member of the, what do you call it, Sean, faculty? We're supposed to teach classes And they said, sorry, we need you back down in Bogota. So we went back down, worked on a list of all the things that they disagreed on, came up with a revised agreement which was publicly announced in December. And as Andres said, everything was connected to everything else. So nothing was agreed to until everything was agreed to. The justice package was basically agreed to in December of last year, and then had to wait for all these other things that you heard about. I should say that on the first day of meeting my two Colombian colleagues, knowing what our assignment was, I went up to Manuel José Cepeda, a very distinguished Colombian lawyer, teammate, former president of the Constitutional Court, and I said, what do you think our chances are? He said, well, what do you think? And I said, well, I don't think this is misión imposible. It's not mission imposible. I said, I think it's misión casi imposible. Mission almost impossible. And from what we've seen up to date, that initial assessment seems to continue to fit. Now, what did we agree to? I should say first, however, there were significant international law constraints. And for those of you who are studying international law, or for those of you who are studying peace studies and wonder whether international law matters a lot, or at all, I can tell you that in Colombia, in these negotiations, it mattered tremendously. Not a day went by in the negotiations where the issue of the International Criminal Court, to which Colombia is a party, did not come up. The very first paragraph of the Justice Agreement is a verbatim quote from the InterAmerican Court of Human Rights. International law was all over those negotiations. There were a number of times when the FARC lawyer would propose to let them off the hook or let them off the hook on this or that, and I was able to answer, you can't do that. It would be a violation of international law. It's pointless for us to even try to agree to it because the agreement would be invalid. For example, the Inter-American Court but international law imposed constraints, but also possibilities. On the constraint side, the Inter-American jurisprudence basically provides that there can be no amnesty for atrocities. Now, there have been amnesties for atrocities throughout history, but in the last 15 years in the Western Hemisphere among parties to the Inter-American human rights system, you simply cannot provide an amnesty for crimes against humanity, war crimes, genocide. There was no genocide that I know of in Colombia, and those kinds of serious violations of international human rights law. And it's not enough just to not have an amnesty. There's a positive obligation on states to investigate, to prosecute, and if found guilty, to punish proportionately the perpetrators of atrocities. So that's a pretty tall standard to meet. And if we had had to meet that standard in Colombia, there would never have been an agreement. Fortunately for the Colombian negotiations, in 2012, in the case involving the massacre of El Mozote in El Salvador 30 years earlier, in 2012, 5 of the 7 members of the Inter-American Court had published a concurring opinion in which they indicated that in a situation of peace negotiations, where peace is in the balance, a government has an obligation not only to protect human rights, but also to secure peace, and that it must pursue both obligations with equal zeal. And part of the rationale for that is that obviously punishments of human rights violations relate to the victims of the past. But if there is no peace, there will be victims of the future. And so governments have an obligation to try to address the needs of victims of the future by preventing them from being victims, by ending war, as well as an obligation to pursue justice for the victims of the past. And this means, said the Inter-American Court, that states are free to pursue alternative sentencing mechanisms reduced punishments, coupled with truth and reparation-seeking mechanisms, rather than simply insist on prosecuting every perpetrator to the hilt and imposing 30-year prison sentences. So that gave us the running room we needed for the negotiations to be serious. And the result that we came up with is a unique package. First of all, it provides that there will be an amnesty for political crimes, the very act of rising up in rebellion, in fact, of carrying arms illegally in a country. Those are illegal in every country, but they are amnestied under the Colombian Agreement, and that is recommended by the Geneva Protocol of 1977, which calls for the broadest possible amnesty at the end of the Civil War so that the parties can reconcile and live together in peace. But there's a big exception to that amnesty, and that is no amnesty, according to the interpretation of the International Committee of the Red Cross and others, no amnesty for war crimes, crimes against humanity, and that sort of thing. What about the crimes that cannot be amnestied that were committed in Colombia? And there were many, many thousands of them. Our agreement is extremely complex, and so I'm going to grossly oversimplify here. But basically, that for alleged perpetrators of atrocities in Colombia, there are two tracks: the fast track and the slow track. The fast track requires you to come forward and to disclose the full truth of what you did. And the full truth is defined pretty broadly in the agreement. And to publicly accept personal responsibility for your actions. And that, in and of itself, is an important aspect of moral reparations for victims experienced around the world. And my personal experience in a number of countries shows that to be the case. And to commit to provide reparations for the victims of your crimes, and to commit to non-repetition of your crimes. If you do all of those things to the satisfaction of the court, then you can be sentenced to 5 to 8 years, consisting of two aspects. One, reparations work for the victims. Building bridges, rebuilding a town, demining a field, etc. And two, effective restrictions on your liberty of movement and residence. What is an effective restriction on your liberty? Nobody knows. We couldn't reach an agreement on that, and so if any of you happen to be selected as judges to sit in Colombia in the coming years, it's the judges who will have to decide, assuming this agreement were to go through. What if you fail to meet any of the conditions I just met? Full truth, public acceptance of responsibility, commitment to reparations, commitment to a performance of non-repetition. If you fail on any one of those, you're not eligible for the fast track, and then you go on the slow track. What's the slow track? The slow track is a normal criminal trial. And if you're found guilty, 15 to 20 years in prison. Sorry about that. The idea there is to incentivize the perpetrators to go the fast track route, to tell the truth, to come forward, to accept these reduced and alternative punishments so as to avoid facing 15 to 20 years in prison, but at the same time not to put all our eggs in one basket, to say, all right, if you don't meet all those conditions, you can be tried and fully punished for your crimes. Now, none of this was to be done before the ordinary Colombian courts. Instead, we created a special tribunal for peace, or at least the agreement would create a special tribunal for peace to administer all this. Why is that? Because having been in a civil war with the Colombian state for 52 years, the FARC guerrillas do not trust Colombian courts. I don't know if there's ever been a Colombian court proceeding between the FARC and the government where the FARC won. The FARC considers Colombian judges to be hopelessly prejudiced against the FARC. So they wanted to have a special tribunal which, while composed primarily of specially selected Colombian judges, selected for their expertise and independence, would also include 4 international judges. And you wouldn't have to have an international judge on your panel, but you could ask for 2 of them to sit on your panel and on your appeals panel. And this gave the FARC comfort that they would get fair and impartial justice from the Special Tribunal for Peace. This arrangement, which I've oversimplified, met the acceptance of the FARC, which wasn't easy, took months to do, met the acceptance of the government, which wasn't easy. There were a lot of people in the government who regrettingly accepted it. And very importantly, it also gained the acceptance of the Colombian military, because the 3 of us who were negotiating with the FARC lawyers also had to be negotiating with the high command of the military. I remember walking into the military high command conference room one day. I'd never seen so many generals and admirals in one place in my life, and the room was full of brass all over the place. And it was our job to explain to the military that not only the FARC had to face transitional justice, but the military too, that there could not be impunity for those generals and colonels who were accused of superior responsibility for atrocities. It was also something which, in my judgment, is consistent with the jurisprudence of the Inter-American Court in the Sote case, and based on discussions that we had with the International Criminal Court. We thought maybe they would buy it as well, and indeed, just a month ago, the ICC prosecutor came out with a statement which, while not embracing or endorsing this approach, also did not fully reject it. But, as Andres mentioned, by a vote of, it was even narrower than 51%, it was 50.2% to 49.8%. The voters voted it down for a series of reasons, and if you listen to the reasons, some of them had to do with the peace agreement. Some of them do not. For example, if you track the voting results for the peace referendum with the 2014 presidential election, where President Santos won re-election by a hair, you will see that the voting totals, district by district, are very similar. And so to some extent, this was a referendum on President Santos. And President Santos, who I admire tremendously, I consider him to be a man of courage and commitment. He was willing to sacrifice his political career in the pursuit of peace for his people. The fact that he's not very high in the public opinion polls meant that the peace agreement faced some rough going, and much rougher going, frankly, than anyone, including the leader of the no vote, President Uribe, had anticipated. But it's been voted down now. And where do we go from here? Well, 3 or 4 days after it was voted down, as probably most people in the room know, the Nobel Committee, in its wisdom, decided to award the Nobel Peace Prize to President Santos as a way of basically encouraging all parties to go forward in pursuit of peace. A second encouraging sign is that all the major parties have indicated that they want to pursue peace. The FARC, the government, and the no vote, the leaders of the no vote have said, we want to pursue peace, we just want a different peace than this one. And within the last few days, the second major guerrilla group in Colombia, the ELN, has also announced that it wishes to join in formal peace negotiations, which will begin within a few weeks. Up until now, the ELN, which is a smaller guerrilla group than the FARC and very different from the FARC, had not met President Santos's preconditions for public peace negotiations, namely to release the prisoners that they have. But they've now agreed to do that. There are only apparently 2 prisoners that they have, and agreed to release them, and so full peace negotiations can begin. President Santos has announced that there will be the bilateral ceasefire will remain in place until October 31st, and can be extended after that. So there are many reasons to think that it's possible that further very difficult negotiations will lead to a peace in Colombia. I say a peace in Colombia rather than a peace agreement because it's not clear that the procedural route for peace will necessarily be a revised agreement. It may be a legislative fix. It may be some separate agreements in addition to this agreement. There are all kinds of ways and options they could pursue if they choose to, one of which might be to reopen the agreement. Now, the no coalition is not monolithic. There are a number of strains in there. But the leader of it, the single most important no voter, is former President Álvaro Uribe. And this Monday or Sunday, he came out with his list of 8 items that he says have got to be fixed. Most of which do not have to do at all with the justice agreement. He wants the government to retain the faculty to provide aerial fumigation of drug cars. You can debate that issue one way or the other, it doesn't affect justice. Land. He says the agreement should not affect honest landowners whose good faith should be presumed, irrevocably presumed, in the absence of any crimes that are proved against them. Now, I personally find that very revealing about some of the economic interests behind the no vote, but again, it has nothing to do with the justice agreement. Who will pay for the costs of the post-conflict? They're going to run into the hundreds of millions of dollars. And by the way, President Obama committed, and a bipartisan Congress, Republican and Democrat, agreed to provide hundreds of millions of US dollars in support of implementing the peace agreement in the future, of course, if there is a peace. But Álvaro Uribe wanted to make sure that Colombian taxes were not raised to pay for it. That's an issue, again, it has nothing to do with the justice agreement. He wants local mayors and governors to retain autonomy and not to be bound by some of the political commitments made in the peace agreement about rural redevelopment, for example. That could be debated. Again, that's not part of the justice agreement. Consultations to communities. He wants to make sure that public consultations with communities do not get in the way of development. A very contentious issue, again, nothing to do with justice in the sense of the justice agreement. Political participation. This was, again, something I had nothing to do with. But in the last few months, the negotiators agreed, as you heard from Andres, that the FARC would be guaranteed 10 seats in the Congress, 5 in the House and 5 in the Senate for the first 2 terms after they demobilized. That is a huge point of controversy and one of the significant factor in the no vote. Uribe doesn't object, interestingly, he doesn't object, as I understand it, to giving them 10 seats. He just says those 10 seats cannot be occupied by anybody who was responsible for war crimes. Well, that sounds reasonable, except there's a problem. All of the FARC comandantes would be knocked out. Ivan Marquez, the lead FARC negotiator, has 40 convictions outstanding against him. So the FARC are not very happy about the idea that you'd have a war crimes test for whether one of their people could occupy one of those 10 seats. But again, that's not part of the justice agreement. The final 2 of Uribe's 8 key points, bottom line points, do have to do with justice. One of them has to do with the punishment. Interestingly, he does not demand prison time. I'd like to think that's because he knows prison time has been unstarted, and he's trying to find something that might actually be doable. Instead, what he says is, instead of the effective restrictions on liberty that I mentioned, and that are in the agreement, he wants to have effective reclusion, punishment, which is privativa, which is you're deprived of your liberty, in alternative sites such as agricultural work farms. Personally, I'm very happy with that. Personally, between us, I'd like to see prison time for people who did these things. We didn't get prison time, and we didn't get a precise definition of effective restrictions on liberty, not because we didn't want it, but because the FARC would not accept it. I'd love to see accept something like President Uribe proposes. I'm very skeptical that they will, but on the other hand, there's now a somewhat changed political situation in Colombia. Maybe they would at some point be open to it. Frankly, based on all my discussions with them, I doubt it very much, but I can't blame President Uribe for coming up with that kind of a suggestion. The final one is perhaps the biggest one, and that is he objects to creating a special tribunal for peace outside the ordinary Colombian justice system. He suggests creating a special chamber in the Colombian Supreme Court to do this work. Now, objectively and rationally, that's a reasonable proposal. The problem is, again, that it's asking the FARC to submit to the judgment of the enemy, something they would not, or who they perceive to be the enemy, something they are not keen on doing. Where is all this going to lead? If anybody in the room here knows the answer to that, please see me after this session and we'll be on the next flight to Bogota. There are a lot of uncertainties. There are basically two possibilities. Humpty Dumpty has slipped off the wall. Either we're going to find a way to put it back together again and up on that wall in a slightly new form, patch up his eggshell, or we're not. In other words, either we're going to get a somewhat revised peace arrangement, or we're not going to have any kind of a formal peace agreement at all. And then we'll be under a situation where maybe there's a ceasefire, but maybe some incident occurs and the ceasefire breaks down. After all, that happened a couple of times in the last several years of negotiations. We may be looking at more armed conflict in Colombia, or we may be looking at a peace that takes a little longer and looks a little different than the one that was negotiated. Personally, I am guardedly optimistic that the scenario will result in a somewhat revised peace arrangement. That's what Colombians want. That's what Colombians need. That's what they deserve. I hope they can get it, but there are no guarantees. Thank you very much.
So, thank you so much, Professor Cassel. So, as you mentioned, probably the justice component of the peace process and peace agreement is the less controversial, or I think the more solid one. But there is this combination between political participation and the mechanism of justice that in none of the sanctions that the process that tribunal might impose involve the suspension of all political participation, right? So you could have the idea that some of the people that were directing guerrilla, maybe even Timochenko, they will be convicted or sanctioned because they accept responsibility. So they have 5 or 8 years, let's say 8 years of alternative sanction, which we don't know, as you said, what's the restrictive measure. It might be just to live in a chosen place ordered by the government, not being able to go out from the city, and at the same time being able to participate as a congressman because of the 10 seats. So you might have this option, like reasonable option, according to the process of justice, that you will see Timochenko in the Congress, right, after he's been committing these kind of crimes. So the first thing is, one wonders is if this process of effective remediation for victims might be just a mock in the sense that he accepted the truth, but he said that at the end, a very easy salary paid by Colombians that were victims of Timoshenko. What do you think about it?
Well, first of all, political participation by the FARC is absolutely key. And the whole message of the peace negotiations was, you guys have been pursuing for your entire adult lives, which is literally true, a set of political objectives, or say you have, by bombing people, shooting people, killing people, kidnapping people, and engaging in other crimes. If you really want to pursue your political objectives, do that, but do it through lawful, peaceful, democratic process. So it's central to the peace process to have the FARC able to participate in the democratic political process, and it's not unreasonable, I think, to give them a kind of a kickstart with a few seats in the Congress, not enough to win any votes, obviously, but just a few seats to give them a foothold for a short period of time. That said, I wasn't involved in the part that said, well, Timoshenko could be one of those guys, or Ivan Marquez could be one of those guys. We already knew that the reduced criminal punishments for these guys would be controversial. If you had told me that in addition to giving them a light punishment, we're going to put them in Congress, and asked me, how is the Colombian public going to react to that? I would have said, hey, is this really a wise thing to do? But I wasn't asked that question. I learned about it when everybody else did with the big public. I think that's a powerful combination and had a lot to do with the no vote. Uribe is now saying, let's prohibit people who have responsibility for atrocities for being one of those 10 seats, but he's saying that at a point where the FARC comandantes have already sort of probably privately divided up who's going to get which seat where. It's going to be a very difficult problem to solve. As far as feigning the truth, of course there's a problem that somebody could give a false confession or leave things out. The part of the details that I left out about the Tribunal for Peace is that they will be receiving information from everywhere, from the Colombian courts, from the Colombian military intelligence, from foreign government sources, from NGOs, from the prosecutor. And they'll have all this information they can compare to somebody's confession. And if somebody comes in and says, I confess to stealing a candy bar, on the 3rd of September in 1997, and there's evidence that maybe the person did a little bit more than that, the court does not have to be deaf, dumb, and blind. So I think the court has the tools it needs to get past any feigned confessions.
So, related with that, with your answer and with the question of effective remedy of the victims, which is the center of the justice mechanism. So the InterAmerican Court jurisprudence says that part of the rights of the victims to receive effective remedy involves reparation, which part of the reparation is symbolic and also economic, right? So the part of the symbolic part of the reparation might also be granted, well, very related with the truth, that is part of the essential part of the justice system. However, about the economic reparation, it seems that the reparation is going to be paid by the state, right, and not by the FARC, not by the perpetrators, and they're going to pay it with Colombian taxes. And so one of the questions is not like in a problem or a violation of the effective remedy of the victims, that the perpetrators are not really the ones paying the compensation for the victims, and rather stating the one if they have to.
Another excellent point. In relation to all of these points, I think it's important to bear in mind a statement that President Santos made during the discussions on this agreement. Every peace agreement is imperfect. You can ask the COC people because they've collected all of them. There's no perfect peace agreement anywhere in the world. Why is that? because it's inherent in the nature of peace agreements that there are negotiations in which both sides make concessions. Every peace agreement is imperfect. And what President Santos said, and I think really sums it up, is, I'd rather have an imperfect peace than a perfect war. Now, with regard to reparations, yes, the victims are entitled to economic reparations, and it is the duty of the state to provide those reparations if the money is not forthcoming from somewhere else. What about the money that the FARC supposedly have? Probably everybody in Colombia believes that the FARC have enormous treasures stashed away somewhere from all their profits on kidnapping, and they claim they don't traffic in drugs. They say what they do is they tax the drug traffickers. But however they do it, they got a lot of money from the drug trafficking and from kidnapping. What happened to all that money? Well, part of it obviously went to pay the expenses of an army in the field, which at one point was as high as 15 or 20,000 combatants over a long period of time. They still have about 7,000 combatants in the field who need to be fed, equipped, armed, trained, and transported and so forth. But what about the rest of it? In the negotiations, what the FARC told us is, we ain't got none. I have my doubts. But it's awfully hard to prove it. You know, with all of the resources of the U.S. government, the U.S. Drug Enforcement Agency, the CIA, the Treasury Department, and all the resources of the Colombian government, they have been looking for this hidden stash, and they haven't been able to find it. Now, when the FARC tell the truth, which makes them eligible for reduced penalties, part of that truth is, did you get money from this and where are you? And if they say, nope, or got it but we spent it, how are you going to prove that's wrong unless somebody can find that money? So there's a real problem out there. I don't know where they've got it, if they have it. But that may mean that we'll never get the money from the FARC, in which case the victims still need to get reparations, and it should be the government that pays for it.
So I think in the sake of time, I'm going to just ask one question more. So it's a very general one, but if you had the possibility to change something of the transitional justice mechanism now, that is like in a process of renegotiation, what that would be?
For me, that's easy. I would accept President Uribe's proposal to tighten up the definition of restriction on liberty. I think that would send a good message. Whether you can, your question presumes I can get this. I can propose all kinds of things that I can't get. I'm not sure I can get this because the FARC so far have said while they're willing to listen to anybody, they're not willing to renegotiate the agreement. I don't believe that. In other words, I think if a package were developed that they thought on balance were in their interest, I think they would drop their objections. But I think it's understandably their position now is until something acceptable alternative comes along, they're gonna stick with this one. Normally, I understand these programs go till 1:30, but Andres and I are happy to stay here and take questions from any of you for as long as any of you want to pose questions. There might be a class at 2 p.m., I don't know, in this room. If there is, we'll get booted out by then. And on the other hand, any of you who need to leave, please feel free to do so with no embarrassment. So, questions? Yes,
one thing that really troubles me about the trial that 8 years confinement, when you read the report, the trial 8 years confinement, and it says, loss of liberty and residence within this language, it says in no case this means so it's almost kind of funny the way the language is sequenced, which kind of leaves a punchline. Well, if you're not in residence, you're not in prison. So when they negotiate, if the FARC leaders who know that there's a good chance they'll be convicted of war crimes, and they have influence in the negotiations, and the topic is where they're going to spend their 8 years. I mean, it's just surprising me that this is the issue that they left unspecified, and they have an opportunity to go through where they would spend it. What were the options?
There were numerous options. I'm asked to repeat the question, and secondly, I'm told there's no class in here until next Tuesday. No. We have some time. We don't have to worry about another class. The question is, what are the options for these effective restrictions on liberty, other than, say, house arrest? And why weren't they specified? Why was it left open? The answer as to why they weren't specified is that we on the government side had a pretty strict idea of what these restrictions ought to be. Like, you're told you're going to live in this house and you're going to work on that farm, and that's it. The FARC wanted to have a loosier idea of the restrictions, and since we could not agree, we basically kicked the can down the road. It would be up to the judges to decide the restrictions on a case-by-case basis. And the judicial order will say, Bob Johansson, known FARC comandante, is confined to the community of South Bend in the neighborhood consisting of 6 square blocks, and he will have to go out with a pitchfork and dig up Route 31 all the time when he's not actually in his house. Or he'll say something different. We don't know what the judges will say. Next question. Yes?
Another interesting thing that Uribe doesn't want is for drug trafficking to ever be considered a political crime, but the agreement also doesn't designate it as a crime that isn't eligible for amnesty. So I was wondering what the discussions regarding drug trafficking.
Well, the discussions on drug trafficking were the FARC saying, we don't do that. I mean, really, that was their consistent position. So my recommendation, which I have made publicly and privately, but so far it doesn't seem to have been taken up on, to the government has been, there is a provision in the agreement that says ordinary crimes, including very serious ordinary crimes like drug trafficking, cannot be amnestied. If you commit a private burglary or a private murder, that can't be covered by any amnesty in this agreement. This agreement is about amnesty for guerrillas who rose up in arms and reduced punishments for people who committed war crimes. But it's got nothing to do with ordinary street crime. So my suggestion has been, why don't you pass implementing legislation to the agreement that specifies that drug trafficking is not included in any amnesty and will be prosecuted before the ordinary courts. How is the FARC going to object to that? They claim they didn't do any drug trafficking. So far that idea does not seem to have caught fire. Yes?
Well, first of all, thank you for the talk and congratulations for your participation in the whole peace process, which I believe is extremely important.
Thank you.
My question is regarding the congressional distribution issue we were talking about previously. And I want to know what is the legal logic that was followed in the agreement to grant parliamentary representation to a group, which in this case is the FARC, without a democratic process to elect their representatives. How is it legally and constitutionally possible? Because it doesn't seem to me that any of the branches of power in Colombia could be able to do this arbitrary distribution of seats without a direct participation of the people.
Whenever I've gotten questions over the last year about legalities and constitutionalities in Colombia, I've always said, ask my 2 colleagues. They're both former presidents of the Colombian Constitutional Court. I'm not an expert on Colombian law and constitution, so I can't answer your question except to say that, as I understand it, there are a number of areas, in fact, Andres mentioned this, where constitutional amendments will be necessary in order to implement the agreement. And there's a process for having those constitutional amendments approved on a fast-track basis, and that's part of the controversy of the no vote. And I assume that to get the 10 seats, you're talking about a constitutional amendment. But beyond that, you'd have to ask my 2 Colombian colleagues. But thank you very much. It was certainly an honor to be able to try try to walk with the Colombian people in their pursuit of peace, and to try to help President Santos bring this about. Yes, sir.
Yes, President Santos said he would abide by whatever the referendum resulted in. So obviously it was no. But earlier in the presentation, you mentioned that the referendum might already be binding. Do you see the FARC trying to enforce the agreement? And if so, what remedies does the Colombian government have to try to make it not enforceable?
Yeah, I mean, the FARC is definitely trying to enforce the agreement. It's been filed in Geneva. They're trying to say it's an international agreement under the Geneva Conventions. It can't be altered. But it's not, I don't think it's going to be treated as an enforceable agreement. There are many ways that the Colombian government can effectively get around that agreement. And when I don't think President Santos said he would abide by the no vote. I think what he said was he wouldn't enter into any agreement unless it had the support of the Colombian people, which is a little different. So there are all kinds of things that are being discussed in Colombia right now. One possibility is they reopen the voting a bit for some of those districts in the north that were hit by the hurricane, where voter turnout was very low, and where the polls show, and the voting totals show, strong support for a yes vote. And if you did that, you might end up changing the result from 49.8 plus to 50.1 plus. There are others who talk about having a whole new referendum, having this one get invalidated by the Constitutional Court, and having a whole new referendum. There are others who talk about going various legislative routes. So there are many ways that are being actively discussed in Colombia right now about how not to be hamstrung by this agreement. And my sense from everything I've read is that this agreement is not going to dictate the terms of the future. There's going to be a change. How exactly that change will be achieved, I don't know. But there are many ways to do it that are being discussed. Yes.
Yeah, thank you very much. You've done a great presentation, and thank you for your important role in the middle of it. On the question of the special tribunal, which the No Coalition has objected, can we conceive of some other form of tribunal? I mean, they talked about a chamber of the Constitutional Court, some way in which some of the international protections that were part of the tribunal might be incorporated into some new, more domestic version of it.
Yeah, I forgot to re-ask the earlier questions, but I will re-ask this one. The question is whether we can reformulate the special tribunal to make it more domestic and therefore more acceptable to Uribe. And the answer in theory is, of course, you can. It's just a question of who's prepared to agree to what. You could move the whole special tribunal into a special chamber of the Supreme Court, as Uribe proposes, if the FARC would agree to that. If they don't agree with it, then you don't have a peace agreement. Yes, sir.
In the Colombian context, would you sort of say that there have been two major power players, specifically the FARC and the government?
Well, more, but okay.
Right?
There are multi power
But
players.
there have also been powerless players. In particular, the indigenous, the campesinos, the ones in the rural areas. I believe I read something that they requested a place at the table in the negotiations, but I have seen no confirmation that they actually did. What is your collection of that process, and what can be done to ensure that those who are most adversely affected by the conflict, those against whom most of the atrocities have been committed, do have a place at the table?
Excellent question, thank you. The question is, did those who are powerless, those who are most affected by the conflict, have a seat at the table? And the answer is yes and no. They had more of a seat at the table than in any other peace negotiation that I know of. The government and the FARC agreed, and the Catholic Church and the universities implemented a program by which they brought delegations of victims to Havana over a period of several negotiating sessions to confront the FARC directly, face to face, with the crimes the FARC had committed. And in some cases, the result was a published apology from the FARC. It's noteworthy that Semana, which is one of the major Colombian news magazines, did a sample check after the plebiscite was held. And they took 10 or 12 of the most deeply and harshly affected communities by the war. In other words, victim communities. And they checked to see how they voted. They voted overwhelmingly yes for the peace agreement. In Bujaya, where the FARC had launched an unguided bomb, basically, that landed in a church and killed 80 people or something like that, the vote was 96% in favor of the peace agreement. So to the extent that this peace negotiation and the justice agreement is about victims, at least the anecdotal evidence of several of the hardest hit communities, of the most powerless people, Bujaya's Afro-Colombian community, is that they overwhelmingly support the peace process, and the participation of victims in the peace negotiations was more extensive than any other peace process I know of. Yes. I gotta come back to you.
Consider that some of the no-voters are not exactly following Uribe's proposals. There isn't any way that the government and the FARC can renegotiate the agreement. Having I don't know if it's exactly a seat, but at least consider the proposal of the other no-voters that is. In Colombia, and right now, the last few weeks, there are a lot of movements which are confirmed for yes and no voters, and they claim an agreement now. So the mobilization, it is in Colombia pushing for an agreement. So is any way that the Colombian government and the FARC can canalize, channel these new proposals that the social movements are making?
The question is, how can the government and the FARC, or can they, receive the proposals from many sectors in the no vote? Because President Uribe is not the only no vote. The answer is that President Santos has announced a national dialogue, and he's invited everybody in the no vote to come forward with their proposals. He didn't meet only with former President Uribe. He met with former President Pastrana, another no vote. He met with Alejandro Ordóñez, the former Attorney General, another no vote. He's met with groups of various constituencies from the no vote. So I think that it's important to have a very open phase and then a narrow phase. The open phase should be everybody come in with all your ideas, all your concerns. Let the government listen to those concerns. But then there's got to be a narrowing down phase where they say, look, if we were to accept every no voter's concerns, we'd be reopening 10 years of negotiations. Can't do that. Obviously, the FARC won't agree. So we're going to have to come up with a reasonable list of issues that can be the subject of negotiations. But that can and should be done only after we have first had dialogue with everybody and heard all the concerns. You've been waiting for a while, I'm sorry.
Thank you, Professor. As a Venezuelan, I'm a bit interested in the implications or effects that the peace agreement or future peace agreement could have in neighboring countries. There's been reports and information for a couple of years now that the FARC has members in Venezuelan territory, and my question is, has there been any discussion or negotiation relating the FARC members that are in Venezuela, or possibly or not with the consent of the Venezuelan government, and if they could be is there any mechanism for the agreement to pressure those members to go back and stop running from the government, Colombian government? And if the peace agreement only recognizes Colombian citizens as victims, or could it also recognize the people from Venezuela that are in some way in the not defined borders between Venezuela and Colombia?
Two questions, both very good. Is the concept of victim in the peace agreement limited to Colombian citizens, number one? And number two, what about FARC members in Venezuela and other countries? Does the agreement invite them back in? On the first, there's no definition of the citizenship of a victim in the agreement. So if you're a victim certainly of acts that took place in Colombia, whether you're a Colombian citizen or a Venezuelan who happen to be in Colombia. Now, whether it would reach to victims of acts committed outside Colombia, that's not specifically addressed that I know of in the agreement. We will discuss it, at least in the justice agreement. So I think it would be a matter of interpretation. It could be covered by the legislation. If the legislation were to cover that, I presume it would probably limit it to acts committed within Colombia. On the question of Colombians or FARC members in Venezuela, Timochenko's been in Caracas for the last, I don't know how many years, throughout the peace negotiations. So certainly there are FARC members in Venezuela. I don't remember anything specific in the agreement that would explicitly invite them to come back, but I think the implicit idea is to give them an amnesty for the fact that they were rebels. They won't be prosecuted for having been a FARC member. If they committed atrocities, give them the opportunity for reduced punishment, and give them the chance to resume participation in political life. So I think there's an implicit invitation of FARC members, wherever they may be. Yes.
It's come up several times that one of the concerns about the peace agreement that was raised in the referendum or plebiscite was concerning the amnesty or the lack of strict punishments for the FARC. From an international law perspective, of course, how does this agreement compare with the 2003 agreement around the paramilitaries and the kinds of protocol procedures, punishments that were in place for dealing with the paramilitary?
The paramilitaries got 5 to 8 years of prison. And that was certainly one of the starting points in our discussions with the FARC lawyers. But as I said, the answer was, we're not defeated. We're not going to go the way of the paramilitaries. And the government wasn't too keen on going that route either, because very few of the paramilitaries actually went to prison. And the whole system was rather inefficient and ineffective. So nobody thought that the deal that was cut for the paramilitaries was a good model to follow. But would we have liked to get as much prison for the FARC as theoretically was in the cards for the paramilitaries? Absolutely, yes. Let's take one more question. I see people, yes sir, in fact.
Your campaign got boosted somehow with these declarations by Jose Miguel Vivanco from the Human Rights Watch. Any thoughts on that? I mean, he says still that there is impunity in this agreement.
I've known Jose Miguel for 25 years. We've worked together in many cases. He deserves a great deal of credit, as does Human Rights Watch, for the fight against impunity in Latin America. They are partly responsible for some of the very good jurisprudence we have from the InterAmerican Court outlawing amnesties. And he's a very good lawyer. So I have great respect for Jose Miguel Vivanco. On the other hand, I've debated him about this. I debated him about this in Stanford in May. And my question to Jose Miguel has always been along the lines of, I agree with you. Just go find a FARC guy who agrees with you. If you can find a FARC guy who will sign on to your deal, Jose Miguel, more power to you. I would have loved to get what Jose Miguel wants, which is prison time for the FARC perpetrators. But it became apparent that if we demanded that the peace negotiations would continue to be at impasse, and there would be no peace agreement. And so in the interest of future victims, in other words, achieving peace and ending the war with all the atrocities that occur in a war, we agreed to something which is imperfect. If it weren't in exchange for peace, there's no way I would have agreed to this. And so when I asked Jose Miguel, what would you do? He always answers something along the lines of, well, if there's not justice, there won't be peace anyway, and so you're chasing an illusion here. I think if this agreement or some modified version of an agreement goes through, I think there will be peace with the FARC. And now, as you heard, the ELN is also beginning negotiations, public negotiations. So I'm glad he's out there raising these issues, but I don't agree with it. Well, thank you very much to everyone for